Sangeeta Mandal, can you hear me? Sangeeta, unmute kolua. Unisa mo?
Yes, sir. Yes, sir.
Okay, thank you. Parag Dahal, sir, can you hear me? Sir, unmute kolua.
Yes.
Parag Dahal, sir. Sir, শুনিছে না? Sir,
Hi.
আপনার ভিডিওটো অফ কৰি লওক, আপনার নেটওয়ার্কটো অলপ হেৰি হৈ আছে নেকি?
Yeah.
হয় স্যার।
Ah.
আপনার স্যার ভিডিওটো অফ কৰি লওক, স্যার নেটওয়ার্কটো অলপ হেৰি উইক হৈ আছে আপনার। Dr. Amrit Chandra, sir. Sir, welcome. Welcome, sir. Dr. Amrit Chandra, sir.
Hello. Amrit Chandra, sir. Welcome, sir, to our webinar.
Sir, can you hear me, sir? Dr. Amrit Chandra, sir. Yeah, I will give co-host again. Yes. Yes, I have given the privilege again. There are two, I have seen two devices. Yes, sir.
Yes,
Sir, can
yeah, just sir, I will join from laptop 1 minute.
Okay, okay, sir. Sure, sir.
Are we ready to start, sir?
Sir, just give 1 minute and then we'll start, sir.
Okay.
Okay, thank you, sir. Thank you. Dipanjali ma'am, can you hear me? Dipanjali ma'am. Dipanjali Saikya ma'am.
Unmute কৰিব পৰা নাই বোলে দীপাঞ্জলি শইকীয়া।
Ma'am, if you can, yeah, now I think Dipanjali Saikya ma'am.
শুনিছেনে sir?
Yes, yes, now you are audible.
Okay, sir.
Okay, we can start now then. Is it?
Okay, sir. Oh, yes, yes.
I request everyone to mute their mics. Yes, Dipanjali ma'am, am I audible?
Yes, sir, you are audible, sir.
Yes, you are audible.
Okay, okay, thank you so much, sir. Thank you.
Yes, sir, you are audible.
Okay, thank you, and a very good afternoon to everyone. Welcome to this national webinar on IPR and traditional knowledge, organized by the IIC Kaliabar College in association with the Department of Biotechnology and in collaboration with Department of Chemistry. I am Dr. Virendra Pal. I am the Joint Coordinator of IQSC. I welcome you to this platform of Kaliabar College. I would like to also welcome to all the viewers right now who are listening to us in the YouTube live. This program is live streamed in the YouTube channel of Eklavya of Kaliabar College. And before starting to this program, I would like to give a very important announcement that, dear participants, we will share the feedback form only after the completion of the program. That means we have already shared the feedback form with you all, but the feedback form will be activated after the completion of the program, and it will be remaining for 30 minutes. That means after the completion of the program, the feedback form will be there for 30 minutes. After 30 minutes, the feedback form will be disabled again. So I request everyone, those who are listening to us in the Zoom platform, as well as in the Facebook live, as well as in the YouTube live, to fill up the feedback form within the 30 minutes after the completion of the program. Thank you. And now let us start our program. We will start the program with Saraswati Bandana. Our students, Sangeeta Mandal of 6th semester from the Department of Biotechnology, she is going to perform. I request Sangeeta Mandal to start. Over to Sangeeta. Sangeeta, please.
Okay, sir. Am I audible, sir?
Yes, sir.
Saraswati Vandana. Ya Kundendu Tusharahara Dhavala Ya Shubhravaschavrita Ya Veena Varadandamandita Ya Shveta Padmasana Ya Brahma Shuta Shankara Prabhitibhi Devai Sada Vandita Shama Patu Saraswati Bhagavati Nishesajayadyapaha Shuklam Brahma Vishara Shara Parama Madhyam Jagadyapini Veena Pustakadharinim Abhayada Jaidandhakarapaha Haste Sphatikamalikam Vidadhate Padmasane Sansthitam Vande Tvam Parameshwarim Bhagavati Buddhi Pradam Sharadam Matri Pranam 1, 2, 3 Swastha. Thank you, sir.
Thank you, Sangeeta Mandal, for your valuable contribution. Thank you again. She is our students of 6th semester from the Department of Biotechnology. Now, we'd like to invite Mr. Parag Dahal sir, the convener of IIC, and also the assistant professor from the Department of Physics, Koliabar College, for his inaugural speech. Over to Parag Dahal sir. Sir, please.
Hello, everyone. Am I audible now?
Yes, sir, yes.
Hello, everybody, and on behalf of Institutions Innovation Council of Koliabar College, I welcome you all to this webinar. Hope this session will be interactive, informative, and thought-provoking to all of us. Koliabar College, our college is located in a rural area in middle part of Assam, with undergraduate courses in 3 streams and also with PG in 2 subjects and some vocational courses also. And we are accredited with A grade by NAAC in its last evaluation. Imparting higher education combined with social and human values is our motto. And institutions Innovation Council in our college is just 4 months old. During this period, our focus has been on the pre-incubation level activities like igniting, encouraging, and providing platform to innovative ideas and work plans. And an important lesson and experience that we have learned in this period is that the young minds of our students are replete with wonderful ideas and understanding. We look forward to help these ideas materialize in productive activities. We have also sent 2 ideas from our platform to Yukti repository for further activities. It has already been verified. We are hosting this webinar in association with Biotechnology Department and in collaboration with Chemistry Department in our college. We realized that intellectual property rights is a vital component of the process of innovation and its fruitful application in industry and in practical works. Besides being a part of a culture of Assam so rich and diverse, we see that traditional knowledge in various fields like medicine, food processing, and silk production, etc., are to be protected and are to be utilized for social well-being of our people. These two realizations led us to host today's webinar. We requested Dr. Ambrish Chandra, one of the most distinguished experts in this field, to be the resource person, and he obliges us by accepting and responding to our request. With these words, I formally inaugurate this webinar and invite Dr. Barnali Sharma to introduce Dr. Chandra to the participants here. Barnali.
Thank you, Dr. Parag. Thank you very much.
Thank you, sir. A very good afternoon, everyone. On behalf of the organizing committee, I welcome you all to this national webinar on IPR and traditional knowledge. It is my privilege to introduce our honorable resource person for today's session, Professor Amrit Chandra sir. Amrit Chandra sir, apart from his teaching career, is a distinguished patent agent and researcher who made a significant impact in his field. He holds an impressive track record of accomplishments and has been recognized for his work with numerous awards and accolades. With a high impact factor of 100 plus, Professor Chandra sir has demonstrated his expertise in his area of specialization. He has published numerous papers and articles in leading academic journals, and his work has been cited over 1600 times. Professor Chandra sir is also a design thinker trainer, helping organizations and individuals to develop their creativity and innovation skills. He is an authorized trainer for National Intellectual Property Awareness Mission. He holds a Japan Patent Office Train the Trainer certificate too. As a speaker, Professor Chandra is engaging and informative and passionate. He has a wealth of knowledge and expertise to share. He is committed to help others in understanding the importance of intellectual property and innovation in this today's rapidly changing world. With this, I request Professor Chandra sir to share his knowledge with us. Hope he will inspire and educate his listeners, leaving them with a deeper understanding of the role that intellectual property plays in our society. Over to Professor Chandra sir.
Thank you very much, ma'am, for the elaborate introduction. So it is a privilege for me to be speaking today, and the topic luckily is IPR and traditional knowledge. And as you all know, Assam, Northeast areas, and certain areas in India are very, very rich in traditional knowledge. Okay. So when we talk of traditional knowledge, what do we mean? Okay. So traditional knowledge basically will mean the kind of information that has flown down to us from our great grandparents to our parents and then to us. And we are like giving it next to our next generation. A lot of this content can be in the form of written textual matters. Okay. It could be on websites and old textbooks. Okay. Or it could be transferred verbally from one generation to the other. Okay. So when we talk of intellectual property, basically, okay, IPR is a right which is granted to individual entities for the creative work. Okay. And it could be a product or a process. Okay. But when it comes to traditional knowledge, having a patent in traditional knowledge, okay, it is very important that the knowledge source of indigenous community is also protected, and the inventive features of the invention. So if you have done some invention, that is also protected. Okay. So it is very important that if there is some knowledge which is coming from generation to generation, and if you are able to patent that particular thing, you will be able to stop others from doing the same thing. Okay. So that will be a very, very dangerous situation for the country. So what the country wants to protect the traditional knowledge also, and at the same time, it wants to give a boost to innovation also. Okay. So how can this be done? Okay. So it's very important to balance both the things. So the IPR challenge when it comes to protecting traditional knowledge is that to identify what constitutes traditional knowledge. Okay. And traditional knowledge is at times it is transmitted verbally also. It's not necessary that your grandmother or grandfather would have written down something in a textbook. Sometimes they will just give you some suggestions. Like they will say, okay, if you have got hurt, put turmeric and oil. or if you are like having some wound or something, you put neem over there. Okay, so with neem leaves, the smell of the wound or the pests will not come in the food if you put neem leaves into it. Okay? So there are many things which are flown down from tradition to tradition. It does not mean that you cannot do any innovation. So if neem has been told that it is an antibacterial or antipesticide, okay, that does not mean that you cannot do any innovation in neem. So we'll see the examples how that has been done. Okay, and in order to have this traditional knowledge being protected, there are various organizations who have built very robust systems. Okay, and these systems have a database collection of all the knowledge which is available to the government, and through genetic resources, through traditional knowledge, through folklore knowledge. Okay, so the knowledge that is in the community, all the government is trying to digitalize all that information and keep it in one place, so that we have more of the information. In this step, India has started a database which is called as TKDL, that is Traditional Knowledge Digital Library. And this library documents all the information in digital form of all the Unani, Siddha, Ayurvedic knowledge, whatever they get, they will put it into this digital database. And if anyone is filing in any of the countries, be it US, UK, or Europe, anywhere, so if anyone is filing a patent on a knowledge or a system or a particular thing which is available in this TKDL database, then he will not get a patent on it, because that knowledge is already available in the TKDL. Okay. So many countries also have regulations in place to protect the traditional knowledge, such as requiring informed consent and benefit sharing agreements for the use of traditional knowledge. And whenever you are filing a patent or IPR in traditional knowledge, which has any of the biological resources, okay, so be it plants, be it animal sources. So if you're using any of these sources, then you will have to enter into an agreement with the government of India on the profit sharing. So if tomorrow your patent gets commercialized, the government of India may take 2%, 4%, or 5% of the revenue that you are generating. So that again is a clause in the when you're going for patenting of traditional medicine. And who can share this genetic information, and who can share this thing. So if you're working on a biological product, be it a genetic material or a plant or something, you cannot freely send these samples to a person outside India. You have to take permission from them. Okay, from permission from the government. Okay. So whenever you are sending any biological sample outside India, you have to take a permission. That is again very important. That is because India does not want the biological database or the biological products to go outside. Okay. Again, this is not only in India. This rule exists in all the countries across the world. Okay. And the agreement that I was talking of, when you go with this thing, biological resource thing with the patent, then there is a body called as National Biodiversity Authority, which is called as NBA. And they will provide you their approval in this particular format. And they will also tell you how much of the share they want when the things get commercialized. Okay. Now coming to the examples of how traditional knowledge can be converted into something novel and inventive, and you can get an IPR on it. Okay. So for example, neem is a very well-known source. Okay. Okay. So if you make a pesticide which consists of neem oil, okay, which is obtained from neem plant seeds, jatropha oil from jatropha seeds, turpentine oil, okay, from pine leaves, and you add some inert carriers into it, and you add some jelly forming components into it, and you make a formulation. Okay. Now what will happen if you just spray neem oil on the leaves? The oil will not stay on the neem leaves. It will just move out because it will form droplets and it will go away. Now, if you convert this particular thing into jelly, like petroleum jelly, Vaseline we use, so if you convert it into a jelly form, okay, and if you apply that particular thing on the plant roots or leaves or nodules, okay, then that will stay for a longer time. Okay, and if the particular pesticide demonstrates efficacy in addressing various pest-related issues, then you can get a IPR protection on this particular thing. So you see how the information which was already available, which is already known, can be converted into an IPR. Similarly, there are fertilizers, okay, and these fertilizers can be processed in different ways, okay. The invention introduced fermented neem fertilizer that provides long-lasting activity, guaranteed effectiveness, and pest-repelling efficacy without the need for soil sterilization through pesticides. The process involves fermenting the neem or the neem-derived substance together with the fermented substance at a temperature along with the fermentation substance of below 50 degrees centigrade or below. Okay, and what will happen? The resulting fermented neem fertilizer offers a solution to soil problem and promotes healthy crop growth by suppressing plant breeding, pest breeding, being easy to use and environmental friendly. So if you are making any particular invention and innovation, and if it is more effective, okay, and it is solving some problem, then you can get an IPR on it. So whenever you are thinking of an IPR, you have to think of a problem and then you have to think of a solution. Okay, and how the solution is better than all the things which are already existing. So similarly, you can synthesize a new pesticide repellent, okay, by heating neem extract with azathions and along with neem extract and dialkyl toluamides and volatilize. So when you are heating this particular thing, so this innovative approach enhances the pesticidal and the repellent properties of the composition, resulting in more effective pest control. Okay, so you see the common feature is that there are things which are known, but the combination has led to an increase in efficacy. So if the properties have increased, an IPR can surely be applied for. Similarly, there are various plants. Okay, so it might be possible that, say, suppose neem is known for antibacterial activity or anti-pesticidal activity, or that plant is well known for a disease. But it can also be possible that because of your knowledge or because of your research, okay, or because of your intuitive approach, you found a new use or a new application to that particular plant extract. Okay, so in such cases also an IPR is very much possible. Okay, so oral administration of aqueous extract of B. serrata roots effectively normalize the state of hypoalexuria induced by oral administration of 0.5 ml of ethylene glycol. So this is a test drug. So when you administer this, hyperalexuria is occurring, and when you are giving this extract of B. serrata, this is coming down. Okay, so if the drug is effective, then also you can go for an IPR. You can have a single drug, you can have a multi-drug combination also. That is called as polyherbal formulation. So once the patent is filed, it will get published in the Government of India website, or it will be advertised, and this is how it will look like. So it will contain your name, address, name of your college, and everything. Preparation and evaluation of silver nanoparticles of Plumera, rubra, bark, extract, and its pharmacological screening. So you can take a plant extract, add silver nitrate to it. The silver nitrate will be converted to silver nanoparticles. So in this particular invention, they had evaluated HIV, anti-HIV activity, anti-cancer activity, antioxidant activity, and they found it to be very effective. And then they have filed a IPR patent on this particular invention. So this is how the invention looks like. Again, you can make any herbal formulation for anti-obesity. So they are using various things like gracia, cambodia, black curcumin seed, ginger, garlic, bambusa, apple cider vinegar. They formulate everything, and the herbal tablets were prepared using the formulated herbal formulation exhibited significant benefits in weight reduction. Okay, so if you, through your knowledge and through your testing and evaluation, if you know that there is a set of ingredients that work very good, okay, that can be tested and the IPR can be filed. Okay. So like we were talking about, each and every country wants to protect its traditional knowledge. So neem is well known for its antifungal activity. Okay, and a patent in Europe was granted for this neem. Okay, And it was a very bad situation for the country because neem is a well-known antifungal agent which has been used for centuries in the country. So the Indian government and several organizations filed a petition or case against the grant of this patent, and ultimately the patent was cancelled in the year 2000. Okay, so so it was filed in the 90s and it took 10 years to get the patent cancelled, but it was cancelled. Okay. So after this, a lot of stress was put on a traditional knowledge database, and such databases like TKDL came up. Okay, and now they are very effective in preventing such absurd patents from happening. Similar was the case for turmeric also. So turmeric or curcuma longa it is well known. Okay, and a patent was granted to it in United States. Okay, and then again it was challenged by the Indian government and activists in India, and it got cancelled in 2001. Another very important thing is there is a Kani tribe. Okay, and this Kani tribe had a lot of indigenous knowledge and everything. So they were already extracting antifungal compounds from the plant species. Okay, and this patent was granted because see, there are various things that indigenous community is doing. It is not available on Google. It is not available in any published literature. So when they filed for a patent, they got a patent on this. Okay, but then again, there was a lot of backlash. People protested, and then the patent was cancelled or withdrawn. Okay. So you see, when you're talking of IPR and traditional knowledge, it is very important that both the things are balanced. The rights of the people are also balanced. They get the right to use it, because had some other community or some other country patented this particular thing, antifungal, extracting the antifungal compound from plant species, so they could have sued, or they could have taken this Kani tribe to court of law in saying that this is our patented product, why are you doing it? Okay, so it is very important that such things don't take place. Okay. So in crux, patenting traditional knowledge is not possible. However, there are ways around, like making a formulation or a new improved process. So there is already a process of extraction of, say, neem oil. But if you develop a process of extraction of neem oil which yields higher percentage yield, then yes, you can think of going for a IPR, or you can make a formulation like the one who created this Vaseline grease out of it. So those things can be patented. So when it comes to intellectual property, so the property is very much similar to our intellectual property. Okay, so how are they two same? So when you want to buy a house or a car, okay, what you will do, you will see what is the mileage of the car, what is the cost of the car, how much will it cost for maintenance. Okay, is it suitable for 2 people or 5 people or 8 people? Okay, so you will see all these parameters. Okay, similarly, when you're going for a patent, you will see like what is the domain in which I want to work. Okay, will this patent be useful for my career progression? Will this patent have some commercial value? Are there other people also who are doing similar work? Okay, so if you are trying to patent something which is already sold by Dabur or Himalaya or some other company, then there is no point in patenting that particular thing. Okay. So once you have decided that you want to go, you have to search. You have to do a very in-depth searching and see, like, if you are claiming an anti-obesity drug with 5 components, and those 5 components are already reported by someone else as anti-obesity agents. So the government will tell, okay, these 5 literatures you see, they have reported these 111 drugs, and now you are saying that the combination of 5 will work. Okay, so explain me how it is different from that. Okay, so you will have to explain how the things are different. Okay, that is another thing. Now, if you comes to patent search, where will you go and do this patent search? Okay, now which are the websites where you can do? So one of the most easiest website and most user-friendly website is patents.google.com. Like we have google.com for simple search, you need to go to patents.google.com for patent searching. Okay. And then there is another website called as ipindiaservices.gov.in/public search. Now this website is of the Indian government, where you will find all the patents of India which have been filed over there. Another important website is Patent Scope. So in Patent Scope, you will find all the global data. Global data means all the countries, they will have their database patents deposited in this WIPO, and you can search across the globe. You don't need to go to India site, US site separately, or Europe site separately. Patent Google and Patents Go, both of them are helpful in getting the entire global search. Worldwide SpaceNet is more useful for European patent search. Okay. Now, when you're filing a patent, you will have three things that you need to have in the patent. Okay. If you don't have these three minimum things, your patent will not be granted. You can file it, it can get published and advertised, but the grant procedure will be difficult. Novelty, inventiveness, and applicability. So novelty is a very simple concept. The entire thing that you are claiming, it should not be published anywhere in the world and India. So if you say that my work has not been published in India, but it is available in US, can I file a patent for it? I will say no. Or you say this particular drug is well known in Sri Lanka, but I want to file a patent for it in India. I will say no, you cannot file a patent in India because the novelty is impacted. Your invention should be novel across the globe. Okay. Next feature is the feature of an invention that makes an invention not obvious to a person skilled in the art. Okay. So if say a particular neem is useful in as antifungal. Okay. Now you say that neem oil is effective as antifungal. It is obvious that if neem is effective as an antifungal, the oil will also be effective as antifungal. Okay. Now you have to show what is unique in this. Okay. So you will say that there's some technical advancement. So you will say that neem is not easy to use, but the oil is easy to use. It comes in a small bottle and you can carry it. You can just put one drop and it will work very nicely. And it will work 10 times better than the pure neem. Okay. So you get a technical advantage over there. So again, it becomes patentable. Or you say that if you want to use neem as a antifungal, you will have to carry 10 kgs of neem with you. Okay. But in my invention, you can just carry this 10 ml bottle with you and it will be very economic to carry and it is very economic to use also. And you can use it throughout the year also. Okay. So it should be non-obvious and it should have technical advantage or economic significance, either of these two things. Okay. So if you have either of these two things and it is not obvious to a person skilled in the art, then you get a definite grant on the patent. Next is industrial application. It means that your invention should be able to be used in industry. So it could be fertilizer industry, pesticide industry, agriculture industry. So it is all useful over there. So this is not a very, very strong clause. It comes into picture only when you are making a theory. So you say the theory of gravity or something like that. And if you want to patent such things, then such theories as such don't have industrial applications and they come under this clause. Rest all the products and processes, this goes through very easily, this clause. Apart from these three things, novelty, inventiveness, and industrial applicability, there is section 3, which prohibits certain kind of inventions. So the most important one is 3E. So 3E says that if you are just mixing something, so like neem, ginger, tulsi, honey, you are mixing all this thing and you're making a product and you say, I want a patent on this. The government will say, no, sorry, dear, I can't give you a patent on this. It is just a mixture of all the things. But then you say, no, no, sir, it is not a mixture. When neem and tulsi react with each other, they form a 4 component, which is more potent than all the 3 combined. So this invention is synergistic. Then the government says, okay, yes, now this is something that you have come up with, some scientific thing, and I can give you a grant on this particular topic, this thing. Okay. So it should not just be a mere admixture. It should be more than a mere admixture. The results should be better than the mere admixture. And again, anything which is known in the prior art, that will not be patented. Okay, so aggregation or duplication of known properties is not known. So if you have one drug with antibacterial activity, another with antipyretic or anti-fever activity, and you say my drug combination will work as both anti-inflammatory, मतलब वो सूजन भी कम कर देगा और बुखार भी कम कर देगा. So aggregation or duplication of known properties is not patentable. These are the various forms which are to be filled. Application for grant is form 1. Form 2 is complete specifications where you describe your invention in detail. Form 3, Form 4, and Form 5 are needed. Form 3 and 5 are needed. Form 9 is optional, but it's highly recommended that you go for it when you file the application. It is a request for publication. So once you file your patent, it will be advertised in the Government of India website only when you file Form 9. So when you file Form 9, it will be advertised within a month. Okay. If you don't file this Form 9, again, it will be advertised, but it will take 18 to 19 months to get it advertised. Okay. Request for examination of application for patent, Form 18, and authorization of patent agent is Form 26. There is no fees for it. So once you file the application, the status on the Government of India website will show as filed. Then it will show as published. Okay. And this is how the publication will look like. Okay. So this is the official gazette, Patent Karyalaya. It's a Shashanik journal, official journal of the patent office. So it will have issue number, date is Friday, volume number, date, and it will contain the title, the name of the people, and the abstract, everything. Then you have publication. Application is kept secret for 18 months, but if you request for early publication, it is published within a month. Okay. The portal will look like this, the e-register of the patent office. And once you want to go further for the decision, that is, you want to know whether my patent is grantable or not, then you will have to file something which is called as request for examination. So once you file a request for examination, our first examination report is issued. Okay. So once FER is issued, this is how the FER looks like, and the reply to this FER has to be given within 6 months. Okay. So within 6 months, you need to reply to this particular thing. So once you reply to it and the response is satisfactory, your patent will be granted. Otherwise, they might ask you for an online hearing or consultation also. Okay. So in that case, you have to sit for a video conferencing, explain your invention to the examiner, to the government officials, and once they are convinced, they will give you a grant. And if they are not convinced, it can be a negative decision also. This is how the grant certificate looks like. And this is the granted e-register that you look have. It will contain the date of grant, that is 23/11/2020, and date of recorder. So this date of filing was in 19, and you see it was filed on 25/11/19, and within less than 2 days, less than 1 year, it got granted also. Okay, so 23/11/2020 it got granted. So other patents could be like helix leukemia transport tube. So this invention was very good. What they did, you see these blood collection vials usually, and people in villages have a very big problem that if you collect these vials, they have to be immediately transported to the center. So they developed a unique tube which can be used to transmit a particular blood sample, and it will maintain the structure of DNA and RNA during transport. Yes. Okay. So another important patent was phenoxybenzoyl methane derivatives as antifungal agent. So they made new derivatives and they got the patent on these derivatives. If you go for international patents, this is how the German patent looks like. It's granted in less than 2 months. Okay, so you file it in a proper manner and it gets granted. This is how the German or South African patent looks like. Okay. Apart from patent, there are other IPRs also which are very important, like designs, copyright, and trademark. And all these apply to traditional knowledge also and to anyone. So whenever you are designing something, okay, so anything, suppose you are in a chemistry lab or you are in a herbal lab, and you see that this glassware is very, very good. But if had this glassware had one knob on the top, it would have been easy to pour this liquid. Okay, or had this volume mark been in a different manner, it would have been easier for people to see it. Okay, or the design of the flask should be changed so that it becomes more stable. It does not fall if you just put your hand a little bit. Okay, so or the weighing balance should be different, or the magnetic stirrer could be different. Okay, so whenever you have such things which you want to modify, and you can modify it on paper and get it converted into a design, and you can file for a design patent. Okay, so anything that you can see visually, which you can touch, is a component of design. Okay, so be it my watch, your mouse, your laptop, your pen, each and everything has a design component in it. So these can be modified. So you don't need to make a watch in reality. So the technology in the watch is not the concern. The concern is the look and feel of the watch. Okay, so only the looks of the watch is predicted in the design patent. So other things like if you make a set of articles like cup, plates, saucers, and tray, so this entire thing can also be patented. Similarly, jewelry set, crockery set, sofa set. So these things can also be patented. The application for this goes to Kolkata office, which is very near to you. But if you find an online application, it won't make any difference. Okay. The fees for design application is 1,000 rupees if individuals like you and me apply. But if the university wants to be an applicant, the fees will be 4,000 rupees. And this is the information that you will need to file this design application. And this is how the certificate will look like. And this is how the publication will look like for the design. And so the term of the design is for 10 years and 5 years if you renew it. So it can be renewed for another 5 years. Okay. And design can be for anything. And once you have a design, you can legally exclude others from not making and selling your particular product. That's the most important thing. And these are the kind of pictures that you will need for the design. Okay. So there are various CAD CAM people who are good at CAD. They can draw this, or they are designers, or even we can help you out if you have some ideas with design. So you need to make these designs in this format, submit the application, and you will get a grant in approximately 2 months. So this is how the designs can look like, and this is how the certificate looks like. So this is gas chromatography. This is a floor mopping machine. This is an autoclave. Okay. So by changing a few things here and there, or like making it more user friendly, and you can get a IPR on this. Okay. Paddy cutter, magnetic spectroscope. Okay. If you go internationally, this is how the design certificates usually look like. This is a UK patent, UK design patent granted patent. So it was for a topical gel formulation dispenser, and it was granted within like 20 days. So we filed it on 8th of March, and we got the grant on 21st of February. So date of filing was 20th February, and 8th March was the date of grant. So 8 plus 2, 10 days, the grant was done. Similarly, if you are writing some textual content, okay, be it your books or your notes or anything that you are making, that can come under copyright. So copyright, there are 3 parameters are needed. It should be original. That is one thing. It should have creative component. There should be some amount of creativity in it. Okay. And fixation. It should be fixed on a particular medium. So it should be fixed on, it can be fixed on paper with the help of pen or typing or printing, or it has to be fixed on CD, DVD, whatever it is. It has to be brought into a physical format. Okay. So these are the various things which can be copyrighted: literary work, artistic work like paintings, literary work like books, chapters, poems, all these things, dramatic work, the way you dance and perform, musical work, cinematographic films, sound recordings, all these things can be copyrighted. Okay. Who are the authors of the work? So literary work, the author is the main owner. Music work, the composer. Artistic work, artist. Photograph, the person who's taking the photograph. For the cinematographic film, it is the producer who is the owner. And for literary work, the person who causes the works to be created. So copyright comes with 2 kind of rights: economic rights and moral rights. Economic rights are transferable. Okay. Moral rights are not transferable. So you can, if you have made a written a very good poem, okay, you can sell that for money. So the other person will get the right to reproduce it, publish it, and distribute it. But still, your moral rights are not taken away from you, even if you have licensed it to someone. So moral rights means that even if that person is publishing your poems or your content with your permission, still he has to put your name in at all the places. Okay, that is very important. Okay. So you have reproduction right, distribution rights, right to create derivative work, right of communication to public, right to public performance. So all these rights you get. Okay. Another thing is that anyone he cannot distort the integrity of the thing. So if you have written a poem, he cannot modify the things in his own way and publish it. He has to publish the content that you have written under your name. So the best thing about copyright is that copyright work is for life of author. So if you are 25 years or 40 years, for the rest of your life, you enjoy the copyright. And after your death, next 60 years, your children or your nominees get this right of copyright. So you earn the royalty for your life, plus your nominee gets royalty for 60 years of his life. Okay. So that is the best part of the copyright. So you must have seen there are many people who write a lot of books. Okay. And when they write a lot of books, they get a lot of royalty. And it is kind of a retirement plan for them. So for lifelong, they can, they're selling their books are automatically selling, and they're constantly getting good amount of royalty each and every year. So these are the forms. Form 14 is required. These are the fees. And this is how the copyright certificate looks like. Okay. And so usually when you apply for a copyright thing, there will be a waiting period of around 6 months. So initially it was just 1 month. So waiting period is of 1 month, and after that there will be scrutiny, and it will take approximately 6 to 8 months to get the grant certificate for copyright. These are the various symbols that you have seen. So this just putting the C symbol gives you the maximum amount of right. Okay, it is the least open option. And if you put this symbol over there, that is C with a cross, that is the most restrictive option that is there. So no one has got any rights on this. Again, if you think of a very good trade name, or if you want to make a product, or you want to sell something on Amazon or anywhere, you can also make your own trade name. Okay, or if you devise a new chemical method or a chemical process, okay, you can give it your name. So trademarks, these are popular trademarks that you see, the MACD, Coca-Cola, Columbia, Adidas, and all these things. And the unique thing is that once you have this trademark filed, you can put this TM symbol, and it is when it is registered, you can put this R symbol over there. Okay, so that is the main difference. So trademark registration is optional. Even if you don't register, it is there with you. Okay, but if you register, you can stop this from using it. So this is another example of distillery. So if you can identify which one is the correct one. So this is Bilseri, this is Biliseri, distillery, and Bilisili. So the middle, this third one is the correct one. And you see how just because this distillery is a very, very famous brand and people will just buy this brand, other people have tried to mimic them in order to be able to sell their own products. Okay. So not only the label, even the shape of the bottle has been tried to mimic. They have tried to mimic the same. Another important IPR which comes if you talk of Northeast, Assam, or any part of India, it is geographical indicators. So you must have heard about Assam tea. Now, why is Assam tea called as Assam tea? Why Darjeeling tea is not called as Assam tea, or Assam tea is called as Darjeeling tea? Because there is a difference in the climatic conditions, there is a difference in the soil, there's a difference in the skills of the people who are harvesting and manufacturing this Darjeeling tea and Assam tea. Because of which Darjeeling tea has got a different flavor, Assam tea has got a different flavor. And this is not just a common name, it is an IPR. So if someone is growing, say, tea in some other part of the country, say in South India, okay, they cannot put their label as Assam tea. If they put Assam tea label on the tea which is grown at anywhere other than Assam, then they are doing an IP infringement. Okay, then they can go to, it can, legal action can be taken against them. Okay. So these are the various things, like Nilgiri tea and all these things. So you have Makarana marbles, Darjeeling tea, Kanchipuram silk, Ratlam save. Okay, so there are different kind of IP things which are made by people having special skills in that particular area. So these specialty can come either because of the nature or the climatic conditions. It can also come because of the skill present in that community or in that area. Okay. So again, that becomes very a geographical indicator, and these have got a lot of value. So you must have heard about Swiss watch. Okay, Swiss watch is a geographical indicator. Any watch that is made in Swiss is Swiss watch. Swiss watch. Now it is not just because you can get any other watch in equal quality or even better quality, But because of the Swiss watch brand on that particular watch, the watch becomes of $1,000. Okay, so that is how it is. Similarly, you have for fruits. So these are the fruits which are grown in a particular area. They have a particular taste. Okay, and because of which they are given this particular name, Alfonso mangoes, Alfonso mango. Okay. So they have very unique taste and flavor and everything. Okay. So with this, I will just rest my presentation. I will take a small quiz if you can answer. Can you find out the trade names in this puzzle? Just try to find out some of the trade names within this puzzle. Like for example, I can see AMUL over here, Amul. Okay.
Actually, participants are in muted form. So I asked
Okay.
Dr. Birendra, to
Yeah.
unmute.
Oh,
Dear participants, please respond your query in the chat box.
okay. So this has got Amul, Dettol, Lux, Babool, and Bata, Pepsi, Link, and all these things. Similarly, you see this IP is in this. This is a portrait, so it will have a copyright. This can have a copyright and a design. This logo will have a trademark. The design of this laptop will have a design patent. Okay. Similarly, for this bottle of Coke, the name Coca-Cola will have a trademark. The design of the bottle will have a design patent. Bisleri will be a trademark. So
Participants has already given some answers like Amul, Pepsi, Dettol,
yeah,
Tata, Bubble.
Babool,
Yeah.
Yeah, so all of them are correct. Now answer this particular question. Which type of IP protection the painting painted by artist will get? Painting which is painted by an artist, what kind of a IPR will they get?
Anuradha Hazamsi is saying copyright.
Yeah, Sangeeta Mandal is saying copyright. Yes, yes, that is true. You will get a copyright on a painting which is painted by a artist. What protects the intellectual property created by a fashion designer? So you are a fashion designer, you created a nice suit for someone. What kind of a copyright will it get?
Sangeeta Mandal has given design.
Design.
Durisma gave trademark. Then Tara Deuri design.
Yeah.
Pavitra
So
Varman design.
yeah. So as it says, fashion designer. So design itself comes over here. So basically, it will be a design thing. So all the suits that you see, the famous designers Ritu Berry, Sabsachi, and all those things that you see, they're all covered under design registration, design patent. Okay. So even the bed sheets that you see, you know, so all of them have got these design patents over there. What produces the advanced disc brake for a bike developed by the inventor? So bike ka disc brake. So the disc brake, will it be a copyright, geographical patent, design, or trademark? You understand what is a disc brake? So when you apply brakes, it is not just a rubber brake. You will have this high-end technology. So when that is done, and then when you apply the brakes, it comes under. Okay. So Paranjit Kumar is saying correctly, it's patent, sir.
Patent. Then
Yeah.
Anuradha Hazam says patent. Pranjit Kumar
Yeah.
Bhuya patent. Sangeeta
Ah.
Mandal trademark. Tara Deuri trademark. Deepika Malakar trademark.
Yeah. So
Shilpa
basically,
Sharma
yeah, Shilpa is also correct to some extent. If the disc brake has got some new design, it can also go for a design patent. That is very true. Okay, but it will basically go for a patent because it is a advanced disc brake. So it has got an advanced technology built into it. Okay, so technology is protected by patent. The look and feel is protected by the design. If you are giving this disc brake some name, your own company name, then it will go for a trademark. The copyright will be how to install the things and manual that you have made, that will be copyright. But basically, if one has to be ticked, the first option will be the patent. Which of this is the geographical indication? Which of this is the geographical indication? BMW, Nagpur Orange, ironing machine with steam, PlayStation, World Wide Web. Yes,
So just said it's orange.
yeah, orange.
Yeah.
Yes. So Nagpur Orange is
Nagpur
located
orange.
near name
Thalina
with a
Gautam
place.
says Nagpur
Yes.
orange. Yes.
Yeah, that's very correct. What does
Anuradha
yeah.
orange.
And what does a trademark protect? An invention, a work of art, a logo, or a secret formula? Trademark. So we saw the trademarks like MACD, Coca-Cola, Adidas, and all those things. What does it protect? It is protecting their logos, it is protecting their names, and it is protecting their brands.
Prasuja have given
Yeah.
logos. Yeah.
Logos and names and brands are protected by trademark. Okay. So you know, when you say Air India or when you say a particular brand name, you get a picture of it. Okay. So that is how it is protected. How long will a patent last? So the patent tenure is for a period of 10 years, 20 years, 40 years, or 60 years. I'm not talking of copyright, I'm talking of patents. Yeah. So
Adarsh says is 20, Sangeeta says 20.
Yeah. So for the patent, it is 20 years. For design, it is 10 years. For copyright, it is 60 years. But for patent, it is 20 years. If you write an original story, what type of copyright will you get? Copyright, geographical indication, patent, design, trademark. Yes, it is true. You will get a copyright on it. So if a company develops a new technology that improves its main product, what kind of intellectual property can they use to stop others from copying their invention? So you see a new technology they have developed. Okay, so but it is a technology, then which of this will be applicable? Copyright, GI, patent, design, trademark. Yeah. So correctly, it will be the patent which will be responsible. Tara, Sangeeta, Prashurya. So all these are correct. Okay, very nice. So hopefully it's somewhat clear what is copyright, patent, design. Okay. So whenever you're going for a patent, it is important that first you get the patent or you file the patent and then you publish it. The rights are territorial. Okay. So if you file in India, you get all the rights in India. Okay. And renewal fees has to be paid for IPRs. Patent validity is 20 years, design 10 years plus 5 years, trademark is indefinitely in 10 years block, GI again forever, copyright again it is for life plus 60 years. And any person can apply for patent, design, trademark and copyright. But for GI application, you need to have a association. Only an association or a group of people can apply for a GI. Okay, because GI cannot be created by a single person. It is always a community. So with this, it was a very nice and interactive interaction. So everyone responded very nicely on chat. And thank you very much. You can scan the QR code or you can just type bit.ly/IPR in caps and talk and give a feedback to me. So that will be really, really very, very appreciated. Yeah, so I'm open to any questions that you have. If you have any kind of questions or anything, you can ask.
Yes, thank you, Dr. Amrit Chandra sir. Thank you very much. Indeed, this is the third time We are meeting in an online platform, sir.
Yes, sir. Yes, sir. Very nice to meet you, sir.
Yes, sir. Thank you. So thank you, sir, first of all, for giving a very valuable time for us. And we are very much lucky enough because you are guiding us to move us in this direction. And basically today topic is on IPR and traditional knowledge. And you have discussed very nicely about the patent, copyright, trademark, designs and all, which is very important for us. So, sir, thank you again. And I would like to request the participants, if you have any questions, you can write your questions in the chat box, or also you may raise your hand in the Zoom application. We will unmute you and you can directly communicate with our resource person. I would like to unmute Mr. Sunil Kumar. Sunil Kumar ji, if you are there, you have two questions I have seen. Yeah, Sunil Kumar ji, please kindly unmute.
Yes, sir.
Yeah,
Yes, sir. Yes, sir.
please.
Thank you, sir, for the kind opportunity. My first question is that, suppose, as I have mentioned in the chat box also, suppose a compound or a chemical has been identified from plant B, but it was already known to exist from the plant A, and it is patented for plant A already. Now, for the first time, it has been identified from the plant B. Is there any possibility for any IPR for the
Yes,
same compound identified from the plant B?
Yes, sir. So, since you are using a different plant, there could be some more challenges or difficulties. Like one plant is very soft, one plant is very hard or something, and you will be using a different set of parameters and all. So yes, you can go for a patent for that.
Okay, thank you, sir. Now, second question is that, if suppose I made a drawing or picture or for the design of any bike, suppose any bike, but in real sense, it doesn't exist. Can we go for the design application for the drawing or sketch of that bike or any good or any physical entity?
Yes, sir. Absolutely, sir. You can go for the design. So design
Okay,
companies will not say ki you show me the bike or you send me the bike. You know, they just
okay,
want
sir.
it to be correct in all the perspectives, and if the drawing is correct, they will give you the grant of it.
Because why I have asked, because in the design application, when we prepare the representation sheet, they
Yes.
ask for 4 or 5 photographs of the back view, top view. Then without existence of the physical form of the entity, it is very difficult to take the backside photo, upside photo, top, bottom. Then how we can claim it from single and from only
No,
drawing only?
yeah. So we have designers and they are expert in this. So probably the front and back side will look almost same. There will be some difference in the engine. So if you give the sketch, they can help you with making all the 7 perspectives of the drawing.
Okay, sir. Thank you, sir. My third question is that, when a new technology is made by assembly of already existing small patented technologies, from these small technologies, when a new technology is made, is this new technology fall under any type of IPR? Can we go for any application?
Yes, so you can go for a patent. You have to keep in view the inventive thing that I have told you about non-obviousness, technological advantage, or economic significance. So if these 3 things are there, and then you can go for a patent.
Whether we have to take permission from the agencies of these small patent technologies, or directly we can go for the application?
See, if you can, you don't need to take any permission for it. You can go for the IPR. And once the IPR is granted and you want to go for commercialization, you might need to talk to them and use the technology. But if your invention is entirely, see, it depends. If there is something which is very small increment you have done, then you will have to take the permission. But you have done a major change in the inventions, then you will not need to take the permission.
So
Thank you,
sir.
sir. Thank you very
Thank you,
much.
Sunil Kumar ji, for your very beautiful and important questions. I'd like to invite Dr. Pranjit Kumar Bhuiya, sir, the president of IIC. He has some query, I think. Sir, please unmute yourself. Dr. Pranjit Kumar Bhuiya, sir.
Yes, so my very simple question is that how can we proceed the IPR for the marine resources? Because it is a vast area, the territories are different. How can we proceed for intellectual property right for marine resources?
So like I explained with the neem example, so neem oil is very well known for antifungal and anti-pesticide activity. Okay, but when you convert it into something composition form, you can go for an IPR for it. Similarly, if you pick up something from the marine source and it is already known, plainly you can't go for it. But if you develop a process or a product around it, then you can go for an IPR for that.
Question is that the territory different.
Yes, sir.
Deep ocean.
So your voice is breaking, sir.
Pranjit Bhuya, sir,
Deep
your
ocean.
voice is not clear, sir. Please write your message in the chat box. There is
Okay,
a
later change. Okay.
Yes, sure. Thank you, sir. Dr. Pranjit Kumar Bhuya, sir, the president of ISC Kolyavar College, who is working hard for this program. Thank you, sir. If any questions, please participants, raise your questions. You may also raise your hand in the Zoom application, or you may write in the chat box so that we can directly communicate with our honorable resource person. If you have any query, dear participants, you may ask your questions. Otherwise, we would like to sum up. I have not seen any raised hand. So if you have questions, you may ask in the chat box, or else you may also directly communicate with our resource person. He has already given his communication number, so you may directly communicate with sir.
Yeah. So all the students and faculty members, you are most welcome. There's no issue. I am always available. Hana. You can WhatsApp me your queries, or you can call me also.
Thank you, sir. Thank you very much, sir. So we are coming to the end part of our program, and I would like to invite Dr. Dipanjali ma'am, the assistant professor from the Department of Biotechnology, Kolyavar College, for offering the concluding remarks and vote of thanks. Over to Dr. Dipanjali Singh.
First of all, I would like to thank our resource person, Dr. Amit Chandra sir, for delivering his valuable talk on the topic IPR and traditional knowledge with various case studies and examples. I would like to thank our respected principal sir, Dr. Uttam Kumar Barua, and President Dr. Pranjit Kumar Bhuya, along with IIC members, Kolyabar College, for their coordination and support. I would like to thank all the faculty members of Department of Chemistry and Department of Biotechnology, as well as Technical Coordinator Dr. Birendra Pal sir, Coordinator Dr. Barnali Sharma ma'am, and co-coordinators Dr. Abhijit Sunwal and myself for their collaboration to make the events a successful one. Last but not least, I would like to show my gratitude towards our participants for participating in the event by conveying their valuable time. Thank you all and good day.
Thank you, ma'am. Thank you, Dr. Dipanjali Sekia, ma'am. You're also part of it. So on behalf of IIC, Kolyavar College, Department of Chemistry and Biotechnology, we would like to thank you again for your hard work for organizing this program.
Thank you, sir.
Thank you very much.
Yes, sir. So we are coming to the end part of this program, and there is very important announcement for the participants. That feedback link is already now open. It will be open for 30 minutes. After 30 minutes, it will be closed. So I request everyone to fill up the feedback form. And before winding up, I'd like to request you all, please switch on your camera and come closer to the screen. We will take a screenshot of the moment together. Please, dear participants, अपना लोगों कैमरा तो ऑन कर लो. आप अपना कैमरा ऑन कर लीजिए और स्क्रीन के सामने आ जाइए. हम एक स्क्रीनशॉट लेना चाहते हैं. Yeah, I can see lots of people. Sunil Kumar ji, Rajeshri Bhuya, Pranjit Kumar Bhuya sir, Sangeeta is there, Anupam Medi sir, Gosai San sir, Prasurya sir, Asim, Gangutri Hazarika, Dipankar Nath, Saurabh, Rekha Bora ma'am, Niranjan Fugan, Jadumuni Rajpua, Vijit Sonwal, Sangeeta, Lavita Barua, Silpa Sharma, Trusty, lots of persons I could not name. So thank you again. Just give me 1 second, come closer to the screen with a smiling face. 1, 2, 3. Just give me a moment. I'll just save it. Yeah, one screenshot I've taken. Second screenshot. I will take from the second screen where I can see Timita, Monisha Goswami ma'am, Niranjan Anuradha Hazam ma'am, Deepika. So I will just again make it again a screenshot here. And so thank you very much for giving your valuable time for this national webinar. And again, we'd like to thank our honorable resource person, Dr. Amrit Chandra sir, for giving his very valuable time, sir. So thank you again. And in future also, we'd like to have your full cooperation for guiding us in the journey of intellectual property right. Thank you. With this, I declare this program as end. Thank you very much. Have a nice time ahead.
Thank you, sir.